Okay. I'm State Representative Rob Sampson, and I'm surrounded by a few friends who we'll introduce along the way. But I want to start by saying that I consider this to be a monumental and historic victory for the rights of individuals and workers all across America. As a result of yesterday's Supreme Court decision in Harris v. Quinn, I, along with Senator Markley, who is behind me, are calling for the immediate halt to the forced unionization of personal care assistants in Connecticut. And we are also calling for the end to the forced unionization as it pertains to child care providers as well. The Supreme Court case was a result of events in Illinois, but the same story has played out all across the country, including Connecticut. The fact is that these are not employee unions in any sense. They are unnecessary and are mere political creations designed to benefit only the union leaders and the politicians that support them, and at a cost to the taxpayers, the personal care attendants themselves, and the disabled community that they serve. It has been a long 4 years that we have stood firm fighting this forced unionization effort in Connecticut. The idea that it was enacted into law by Governor Malloy, this legislature, and it stood the scrutiny of Connecticut's courts is an embarrassment. Thank heavens the Supreme Court of the United States has more sense. I want to call up Kathy Ludlam, who is an employer of personal care attendants for the last 25 years, to make a few comments.
Thank you, Bob. Can everybody hear me okay? Great. Can you hear me?
Yep.
Good. Beautiful. Well, I am just thrilled to be here today celebrating this very important decision. It vindicates my role as the employer of personal assistants. The state of Connecticut does not hire personal assistants. I do. And people like me do. And the relationship between a person with a disability and a personal assistant is a very unique one, and the loyalty between us is unusually strong. I will do just about anything for my personal assistants, and they will do just about anything for me. There is no room for a union to interfere in between us and interfere in that relationship. In the disability community, we have a saying, "It is nothing about us without us." And this ruling puts control and self-determination back in the hands of personal assistants where it should be. They should not be required to pay into an organization they have not elected to join, and to fund the goals of an organization they may not always agree with. So this is a great victory for their rights and for us as employers. And so I'd like now to introduce Attorney Joseph Suma of Suma and Bryan. Thank you very much.
I really can't sum it up as eloquently as Kathy has. And this has been a long, hard fight for her. We would hope that this ruling is clear and that the governor and the attorney general of the state immediately stop the agency fee provisions and stop taking money that really belongs to the taxpayers and sending it to the union. Hopefully, Kathy and her group won't be forced to fight anymore and have to go to court to force the state to do this. We're hoping that they'll do the right thing. Thank you.
Also very important to this whole effort was the support of Yankee Institute, as many of you know. So we have the new head of Yankee Institute here also to say a few words.
I'm Carol Platt-Liebau, the new president of the Yankee Institute. And as you know, at the Yankee Institute, our mission is to improve lives through freedom and opportunity. And what we wanted to do is congratulate personal attendants across Connecticut for regaining the freedom and the opportunity to decide for themselves whether they want to belong to a union and whether or not they should be forced to pay union fees against their will. We also want to praise the Supreme Court decision that in effect realized that a personal attendant's exclusive loyalty should be to the disabled or elderly person for whom those attendants care so conscientiously. And we applaud the Supreme Court making it clear that a private home is not a union shop and that personal care attendants are not government employees. Thank you.
Okay. So we can open this up to questions if you guys are willing, and I think pretty much anybody on our...
The gist of the ruling, though, is they can't be required to pay union fees. I mean, you have teachers who opt out of paying union fees, and they're still represented in a sense by the contract. So I'm just wondering, what the effect of, what do you see the effect of this ruling? Does it just stop at you don't pay union fees, therefore there's no union? I mean, where do you guys go?
Yeah. No, the problem was that the way it was set up with the agency fee is like it's set up in the public sector in Connecticut. I may choose not to join the union, but I'm still going to have to pay the agency fee under state law. And what this does is it says for this group of people, they're not really full-time state employees. They can't be compelled to pay agency fees if they don't want to join a union. So, basically, instead of union dues, if I don't want to join the union, I can pay an agency fee that may be the equivalent of union dues or something less based on simply the collective bargaining cost to the union. But what this decision does is saying to the state of Connecticut, you cannot mandate that those people pay those dues. If they want to, fine. But you can't make them, as a condition of employment, pay that money.
The ruling makes no, it doesn't go to what you're speaking about, this forced unionization, right? I mean, it just says you're still in the union, you don't have to pay dues.
This ruling doesn't go that far. What it does say is that individuals can't be forced to pay for the union. And the union still represents them and has an obligation to represent them, but individual personal care providers or child care providers should not, under this ruling, have to pay agency fees if they wish not to.
So they still can unionize, right?
As of right now, they're still unionized.
Right. So, and you have a problem with that?
We have a problem with that, but this is a significant, I guess, steps towards that issue.
Senator Markley, do you have a problem with the? I mean, the Supreme Court left the law. Didn't touch laws that says these people can unionize.
Yeah, I think the Supreme Court generally tries to decide things as narrowly as possible to make the reduce the overall impact of the decision. It's been my position since the beginning that these people, both on the daycare side and on the personal care attendant side, are not appropriate subjects for membership in a state employees union. The heart of that, maybe the most significant part of that, is the payment of the union dues or the agency fees, whatever it is, the financial obligation that you would have towards the union as your representative. That part of it has been struck down. Other parts of it remain. How much further it goes, either legally, because there's other challenges still floating around out there that could affect this, or legislatively, remains to be seen. The legislature may have to revisit this topic because of what the Supreme Court has done in any case, and it might be an opportunity for us to reconsider the entire decision.
Rob or Joe, when you guys say you're immediately calling for the reversal of this forced unionization thing, what exactly do you mean by that? Do you mean the agency fees, or what are you talking?
Right. Well, this is a long and complicated issue, no doubt. And I would say that the crux of it is that we have been arguing for the last 4 years that the folks involved, both the personal care attendants and child care providers, should never have been unionized to begin with. And the biggest reason for that is that they are not employees of the state. In the case of the child care providers, they're private business owners, in many cases family members of the person that they're looking after, and they are ultimately not being paid by the state. The person that is receiving the benefit is the parent of the child who has hiring the daycare, and that daycare is the recipient. And in the case of the PCA, the Medicaid waiver program is paying for the disabled person's care, and ultimately the person who gets paid is the PCA, but that person is employed by the disabled person and not by the state. So there is no employee-employer relationship, which is stipulated in Connecticut law. And the decision that we have in Harris v. Quinn says essentially that because of that, these people cannot be compelled to pay agency fees, which would be required of any person that becomes a member of a union in the state of Connecticut or chooses not to be a member of that union would still be required to pay agency fees. So ultimately what's going to happen here is we are going to give choice back to these people to decide whether they want to be in the union or not, and whether the union is worth paying the dues.
Saying that we should. Then the Supreme Court didn't support you. If that's the crux of your issue, then the Supreme Court decision does not attest.
But I believe it does. In states across the country, the same scheme of forced unionization that no two PCAs got together to form a union. This was a scheme concocted by members of the union and members of government to essentially create a union and a revenue stream that comes out of the taxpayer's pocket. Medicaid waiver money that taxpayers pay that is supposed to go to benefit disabled people so that they can hire people to take care of them. The unions are taking a piece of that money out now. This will eliminate the ability to do that.
Let me just clarify. I think there are actually two issues here. That there are two separate First Amendment issues here at stake in terms of forced unionization. The Harris v. Quinn focused primarily on the issue of agency fees or the forced payment or subsidization of speech by PCAs and child care providers that they didn't want to subsidize. But there's also the issue of exclusive representation. That is, the union claims to exclusively represent everybody in the bargaining unit. But the union can lobby for things that are contrary to what the PCAs might want. For instance, in Washington State, the SCIU has pushed two ballot propositions that have mandated 75 hours of union training against the will of PCAs and employers with disabilities, making the lives of both harder, again, subsidized by union dues and agency fees. But the issue here is that there's a First Amendment right not just not to have to subsidize that speech, but also a First Amendment right not to be to choose your representatives in lobbying the government. Exclusive representation violates that First Amendment right as well. The cases in Minnesota, Parrish versus Dayton, and in Massachusetts, D'Agostino versus Patrick have been filed, and they are explicitly challenging exclusive representation of family child care providers and, by extension here, personal care attendants.
Sir, would you mind identifying yourself?
Oh, okay. I'm Stephen Mendelson. I operate the Facebook group Stop the SCIU from Hijacking Care Providers, and we also have a website at PCAunioninfo.org.
All right, let me try. So these folks aren't necessarily required to join the union, right? But they are required to pay for the representation. Some portion of what the union dues is. So when you say you're asking the state to do something here, right? What are you asking them to do? Because I'm not clear on what you mean by halt the forced unionization.
It's a good question, and I think that the Supreme Court decision is limited in scope compared to what I am actually asking for. But I'm asking for the same thing I've been asking for 4 years, and I believe that this Supreme Court decision goes a long way to getting us to the next step, which would be to eliminate these union organizations and their involvement in this case completely. And I think that's going to become readily apparent over the near future. In other states, didn't require the Supreme Court decision. In other states, I think it's, correct me if I'm wrong, is it Michigan? Governor Snyder?
It was done in Michigan, the legislature. Let me clarify. I probably know what every state out there. In Michigan, this was done by an interlocal agreement, even more underhanded than an executive order, and by Governor Granholm. And then the legislature signed into a law that forbade any such scheme, whether it's child care providers, personal care attendants, or potentially doctors, lawyers, anybody. If the ruling had gone the other way and the unions had won, then there was the potential that any group that received a government benefit could have been shanghaied into a union by a secret mail ballot that nobody would have known about.
Thank you, Stephen. The point I wanted to make is that I believe it's Governor Snyder passed a law recently in, I think it's Michigan, forgive me, and as a result, and essentially said what the Supreme Court decision said, and ultimately gave the choice back to the personal care attendants of the state of Michigan to decide whether they wanted to be in the union or not, and 44,000 of them left the union, a huge majority, and essentially the process got swallowed up in that ultimate change because the people spoke. The PCAs decided that they did not need the benefit of the union to negotiate on their behalf, which is the larger point here. The fact is that ultimately the amount of money that goes into this program and ultimately ends up helping disabled people and the PCAs is appropriated by the state government of Connecticut. It always has. It still is. I mean, you don't need a union to negotiate that. If the will is here to increase the amount that we put into this program, then the money will increase. The only difference is that with the union gets a piece of that money. And this has been my problem with it since the beginning. If the will of the governor and the democratically controlled legislature of Connecticut wants to help these people, we had the opportunity year after year after year after year to increase the appropriation and help them. And they chose not to. In fact, when this bill was being debated on the floor of the House, an amendment was offered to increase it far more than it's been increased just recently, and it was voted down on a party line vote because they didn't want to increase the amount for the PCAs. They wanted the union. And the fact is, just this year, they were willing to pass the increase because the union negotiated it. But unfortunately, some of that money goes to the union, and not all of it goes to the PCAs to help the disabled people, and that's the problem I have with it.
I have something I could add. My understanding is that were this not to happen yesterday, union dues and agency fees would start coming out of my employees' paychecks. The due date was July 1st, which is today, coincidentally. With the way the pay cycles run, they would start seeing that difference on July 15th. So I think what we are asking for, to answer your question, is that not happening, that be rescinded immediately, so that they don't take that hit starting in 2 weeks. Does that answer you?
That answers my question. Thanks.
Should have asked Kathy.
Yeah. Always.
Anything else, folks? Thanks very much.